one.
Good afternoon, everybody. Thank you so much for joining us today. My name is Julie Page. I'm the Communications Director for the Waterbury Regional Chamber here in Waterbury, Connecticut. We cover 14 surrounding towns of the city of Waterbury, and we are so grateful to the team at the Connecticut Paid Family Leave organization that is presenting this webinar with us today. We know that this is a very important topic. A lot of business owners have lots of questions that they'd like answered, and just want to be on top of all of the things that they need to do to get their employees and their companies ready for all of the paid leave changes that have gone into effect and continue to go into effect. So I'm so excited today to be able to introduce to you Andrea Barton Reeves, who is the inaugural CEO of the Paid Family and Medical Leave Insurance Authority. She has an impressive list of organizations that she's been involved in, including the Connecticut Bar Foundation, the Village for Families and Children, the Connecticut Community Nonprofit Alliance, the YMCA of the Hartford region, and the Leadership Greater Hartford organization. Excited to see that. We do have a Leadership Greater Waterbury program, so was excited to see that connection for you, Andrea. And she was appointed to the paid leave organization by Governor Lamont in early 2020, and she continues to spearhead, all of these changes and this effort with the organization. She has been in the Hartford Business Journal's 40 Under 40 and 5 New Leaders to Watch. She was given the 100 Women of Color Award in the class of 2020, and she attended both Rutgers University and New York Law School, so she certainly knows what she's talking about. It is my pleasure to hand it off to Andrea Barton Reeves and to, enlighten us on all of the things that we need to know for the Connecticut Paid Leave Authority. Thanks, Andrea.
Thank you, Julie, for that very warm welcome. And so thank you, everyone, for taking the time to join today. I know it's so busy and we're all just really tired of sitting in our chairs and watching screens, but we're really going to try to make this as engaging as we can and try to give you as much information as we have about paid leave. Today with me, I have Amber Forrest, who is our Executive Assistant at the Paid Leave Authority. And Amber will be from time to time dropping some links into the chat, depending on what it is that I mention around resources. But if you have a question, we really ask that you use the Q&A feature. That is the best way for us to keep track of what you're asking and to provide answers, not just to you, but to others who may have similar questions. So if you can refrain from using the chat for questions and really use the Q&A feature exclusively, that would really be very helpful. So I'm going to share my screen and we will get started. Right.
We can see your screen, Andrea.
Thank you. I usually stop my video and one more. Okay. All right. So let's just talk a bit about paid leave today. We'll skip that slide and we'll go right to our agenda. Today we'll be talking about the overview of the leave laws and the role of the employer applying for paid leave benefits and what paid leave looks like in the workplace. We'll be discussing private plans and registration, and then I'll show you where you can find some additional resources that will encapsulate everything I've spoken about today. And then finally, we'll have some questions and answers. So a bit about the paid leave authority. We were established in 2019, signed into law by Governor Lamont. We have a mission to provide accessible paid leave benefits for families and Connecticut's workforce. And we also are here to help employers and administrators and healthcare providers by offering them tools and training and support so that they can navigate the program. We have 5 primary responsibilities, and those include outreach and engagement, the development of the policies and procedures needed to run the program. We established the trust fund contribution rate, and that is 0.5%, and by statute, it can't go any higher than that. We audit and approve private plans for those employers that choose to offer their own plan in lieu of the state plan. And we also administer the claims for the paid leave benefits starting next year. Here are some key dates that some might be familiar to you and some you might not know. Registration for employers began in November of last year, and the withholding of the 0.5% of employee wages began in January. From February through the end of March, we are accepting applications for private plans for those employers that wish to offer those in lieu of the public plan. Payments are due very soon. They are actually due by the end of the quarter with a grace period through the end of the quarter. So the dates that you see there are actually the end of the grace periods, and first payments are coming in now, and they're actually due March 30th with a grace period of April 30th, and then so on as the dates are listed. By the end of this year, we are hoping to have the portal open where claims applications can be entered and accepted, and benefits should start in January of 2022. Let's talk a bit about which employers are covered by the paid leave law, and also just by family and medical leave in general. So if you are an employer that has 75 more employees, you're already familiar with FMLA, but if you're not that size of employer, this will all be new to you. So the family and medical leave law is changing generally, and it will now cover employers that have one or more people working for them, including nonprofits and private sector employers that have a unionized workforce. If you are a sole proprietor or you're a self-employed individual, you can opt into the paid leave program, but if you do so, you do have to remain in for a minimum of 3 years. For those employers who are not covered, those categories include the federal government, of course, some state of Connecticut employees, not all, and I'll explain what a covered public employee is in a moment, municipalities and local or regional boards of education, unless they too have covered public employees. The only category of employer that is completely exempt from the law are non-public elementary or secondary schools, often known as private or independent schools, which have never participated in the paid leave, in family and medical leave. What is a covered public employee? They are the non-unionized employees of the state of Connecticut, so they are mandated to participate in the plan. Those unionized employees may do so if they collectively bargain to be included. The same is true for employees of municipalities and local or regional boards of education. If you are an employee of a municipality and within the bargaining unit of that municipality, there is a vote to be included in the paid leave program, then everyone who works at the municipality, whether or not they're in the union, is now a participant in the program. And the same rule applies to those that work for local or regional boards of education. A question we're asked quite frequently is, what if my workplace has more than one bargaining unit or more than one union? And the answer to that is that you have to coordinate that effort with the other unions and other bargaining units within your organization, usually through your labor council, to come to some mutual agreement as to whether or not all will participate or not. And you can see at the bottom of the screen that municipality is pretty broadly defined as a town, a city, a borough, and it can run all the way from that to a flood commission or a regional council of governments. A bit about managing the contributions and what exactly are the contributions that are made to the Paid Leave Trust Fund. The contributions are made post-tax, and they are based on the wages that are calculated for FICA. There is a cap on the contribution amount that is made from salary, and that the contribution limit from which contributions are made is $142,800. So any wages earned above that are not subject to the 0.5% withholding. Once those withholdings are made by the employers, they are remitted to the Paid Leave Authority, and we receive them and we validate those wages against data that we receive from the Department of Labor and from the Department of Revenue Services. Those contributions are then deposited into the Paid Leave Trust Fund, and it is that trust fund that funds the benefits for paid leave. So now a bit about our law itself, comparing it to what it looks like now and what it will look like in 2022. So right now, for those employers that are covered by family and medical leave, you are an employer that probably has 75 more employees. Otherwise, as we sit here today, the current FMLA is not applicable to you. But if you have 75 more or more employees, those employees then have to work at least 12 months and 1,000 hours immediately preceding the time that they're looking to take their leave. They also then have job protection attached at 12 months, meaning they're entitled to get their job or a similar job back when they return from family medical leave. They get 16 weeks of leave in a 24-month period, or 26 weeks of leave if they're a military caregiver. And right now, an employer can require an employee to use all of their accrued time their accrued paid time off in order to cover the absences that they accrue while they're out on FMLA. Next year, this law will change considerably. It will apply to all employers with one or more employees. In order to qualify for FMLA, whether it is paid or not, there will be no hours worked requirement, and they will be able to enjoy job protection after 3 months rather than 12 months. Leave will then be 12 weeks in a 12-month period for all of the leave reasons that I will review, with the exception of 26 weeks of leave for military caregiver leave, which is the same in state and federal leave. But an additional 2 weeks is also available when the law changes for incapacitation that occurs during pregnancy. And finally, another significant change is that while an employer can continue to require an employee to use their accrued time off, they have to allow that employee to keep up to 2 weeks of their accrued PTO. Most employers that hear this rule are requiring their employees to exhaust their sick time, but allowing them to keep up to 2 weeks of their vacation time if their time is in fact divided in that manner. If they're using just a large bucket of PTO, then they're required to allow that person to keep up to 2 weeks of that PTO. Some of the reasons for leave, well, actually, all of the reasons for leave are these under the statute: to create or expand your family through birth, adoption, or foster care, or to care for a family member with a serious health condition or your own serious health condition, which could include serving as an organ or bone marrow donor or pregnancy. For our military families, there's 2 types of leave that are available just for them, and that is the military caregiver leave you saw me refer to earlier. That's up to 26 weeks long, with 12 weeks of that being paid. There's also qualifying exigency leave for family members that are called overseas to active duty, which would give them an opportunity to perhaps arrange for childcare and take care of other matters before they deploy. Finally, in Connecticut, our state has a family violence leave statute, which allows a person who is a victim of family violence to take up to 12 days of work, currently unpaid, to address those issues that arise out of family violence. A person can then also take that leave now paid under the law when it changes in 2022. Again, just a reminder of what the lengths of leave are for our paid leave and our job protected leave. So federal FMLA, if this has applied to you before, it obviously will not change. It's still 12 weeks in a 12-month period, and the military caregiver leave remains available. I review the time when Connecticut FMLA will provide time off for people. And what I did not mention here is that, no, actually, I did mention the family violence leave. And then we'll move on to the Connecticut paid leave benefits. So all of the reasons that you can take your job protected leave also apply as reasons where you can take paid leave under the new law. The new law beginning next year will then also be added to the number of laws that are already available for job protected leave. And that essentially means that it's the type of leave that you can take and have a protection of your job being available to you when you return, or in many cases, an identical or substantially similar job. So federal FMLA provides job protected leave as long as you've met the criteria. Connecticut FMLA does so now, as I mentioned earlier, and it will again in next year's changes to the laws. Workers' compensation, the ADA, the Pregnancy Disability Act, and the Connecticut Fair Employment Practice Act, also known as SFIPA, all remain viable laws in the state of Connecticut. Income replacement is now available not only under workers' compensation, but under now Connecticut paid leave law starting in January of next year. So we walked through earlier the eligibility requirements in order to access leave benefits. For a federal, you have to work for your employer for at least a year and work 1,250 hours in the year before you ask for leave. In the new changes to Connecticut Connecticut job protected leave, 3 months of work, no hours worked requirement in order to have job protection attached. But to get paid leave benefits, that is a little bit different. In order to have access to paid leave benefits from the Paid Leave Authority, you had to have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 quarters right before the time you come to apply for leave. And that earnings can be earned from any number of employers and a combination of employers. You also have to have had a qualifying reason for leave, as I outlined earlier, and you have to have leave time that's available that's not exhausted. In addition, you have to be currently working and employed in the state of Connecticut, or you were employed and working in the 12 weeks immediately preceding the time that you're applying for leave. A sole proprietor or a self-employed individual who's opted to participate in the program can certainly do so, but they have to meet the earnings requirements as well. One of the other primary differences between federal FMLA, where that applied, and the Connecticut law is the changing definition of family member. So under federal FMLA, and our law is very similar to that right now, an employee can take time off to care for a parent, a spouse, a child who's under 18, or if they're over 18, leave is available if that child has a disability. When the law changes next year, there will be a much more expansive definition of family, which will include all of the categories listed here, parent, spouse, and the age requirement or restriction for a son or a daughter of any age is eliminated with the change in the law. It's also expanded to include other family members, including those that the employee has a relationship with that is equivalent to these, although there may not be a blood connection. And that is known as related by affinity. And what exactly does that mean? It is any person with whom the employee has a significant personal bond that is like one of the family relationship that's in the statute listed here, regardless of the biological or legal relationship. And one of the examples that is most familiar to people would be a couple that is living together in a spouse-like relationship, but they are not married. So right now, if one of the spouses needed to take time off to care for the other because they were having surgery or a serious health condition of some other kind, they would not be able to do that under family and medical leave. Starting next year for Connecticut law, not for federal, that option will be now available for that person. And so what role does the employer make when they're trying to determine what to do when an employee requests leave? So if you're managing this process internally, and not every employer is, some do have a third-party administrator that does this, but if you're doing it yourself, you want to ask yourself two questions every time a person comes to you and asks for leave. You need to know whether or not they're asking for a job-protected leave under one or more of the statutes that we've outlined earlier. And if so, in addition, you should be asking the question whether they're eligible for any income replacement while on leave. So you have to ask both questions every time, because there might be circumstances where a person is eligible for income replacement, but they don't have any job protected status, or vice versa. As we noted earlier, job protected leave can show up in many forms, one of which is under federal, state, by themselves, both running concurrently. Neither might apply, but they may have job protected leave as a reasonable accommodation under the Pregnancy Disability Act, as an example, or Americans with Disabilities Act, or there may not be any job protected leave at all. So just a few facts about the income replacement that is provided under the paid leave program. There can, in fact, be benefits coordination, which would allow an employee to receive benefits under the authority's paid leave program and any employer benefits such as short-term or long-term disability, but those combined benefits can never exceed 100% of the employee's wages. Some short-term and long-term disability policies that are offered require that the person exhaust their state-provided paid leave benefits first before they can access short or long-term disability policies. And there's no prohibition in our statute that would prevent a person from coming to us first and then, in fact, going to their employer afterwards. But we will be asking employers what benefits are available to that person as an offset to any benefits they might be receiving from the paid leave plan. A person who is receiving workers' compensation is ineligible to receive paid leave benefits from the authority at the same time. And here's another point that is important. A person may qualify for paid leave benefits without job protection. And the reason for that is this. The qualifications for paid leave are to earn that $23.25 in that base period that I described earlier, to have a qualifying reason for leave, to actually have leave time available, and meet the working criteria. Either you're currently working or you had worked 12 weeks right before you apply for leave. You can meet those criteria and be working for your employer for a month, which means that you wouldn't have any job protection, but you would qualify for paid leave benefits. Under those circumstances, we urge employees as often as we can to please communicate with your employer that you're taking time off and you're going to the paid leave authority for benefits, because we do not offer job protection at the paid leave authority. That sits with the employer. So if they haven't worked with you for 3 months, but you'd like them to come back, or you're going to hold their job open, or you're going to offer them an opportunity to reapply, all of those are conversations that should be had with the employee. I will go into more depth about the private plan. And I've already mentioned the requiring of the use of accrued time, so that employers can require their employees to use their sick vacation or their PTO as long as they allow them to keep up to 2 weeks of their leave. So how will the access to paid leave benefits from the authority work? The employee applies directly to the paid leave authority for their benefits. This is not something that employers have to initiate. We then do an initial eligibility screening, which would include making sure that they've met all of those criteria that I noted earlier, including the fact that they've earned enough money and they've worked enough time, and that they're seeking a reason for leave that's actually covered by the statute. We do a preliminary calculation, and then we go back and talk to the employer to see if they're, first of all, they're aware that the employee is going to be away, because we don't want to have any surprises, and to see if there are any offsets that employer provided paid time off may provide to the benefits that the person is applying for from the authority. And finally, we issue the paid leave benefits after all of that is done. So when a person gets benefits, what exactly does that look like? The formula is in 2 parts in the statute. If a person earns less than or equal to the minimum wage multiplied by 40, they receive 95% of their base weekly earnings. If they earn more than that, they get the 480, which is the 40 times the current prevailing minimum wage, plus the difference between what they make and the 480 multiplied times 60. I'll show you a formula in a moment. And but the maximum you can get is $720, or 60 times whatever the prevailing Connecticut minimum wage is. So here are a couple of examples. The first one is Mike, who makes $375 a week. He's contributing about $1.88 a week based on his salary, and he will receive 95% of his base weekly earnings. So that for him is $356.25. Deborah has a very different scenario, having earned $700 a week. So part one is she starts with the 12 times the minimum, 12 times the prevailing minimum wage. The minimum wage multiplied by 40, which is $12 an hour. So she gets 480. And then she gets the difference between what she makes and the 480, and she gets 60% of that. So you can see here, she then gets $612 a week. So let's just look at a couple of examples of how this might be applied. And this is not necessarily the wage benefit requirement or benefit. This is actually how you would apply the application of the, sorry, I'm losing my words for a moment, of the requirement that you have your person use their benefit first before they come to the paid leave authority, and applying that 2-part matrix where you ask whether or not they have job protected leave, and if so, and under what statutes, and income replacement. So let's start with Mr. Coyote, who has worked for a large employer with 100 employees. So we know that he's covered under federal FMLA because of the size of his employer, and he's worked there for 10 years. So he's got plenty of tenure. He's got 4 weeks of sick and 2 weeks of vacation. He has a non-work related injury, so we know workers' compensation does not apply. So his leave looks like this. He qualifies for federal FMLA because of his length of time of service. And he also qualifies for Connecticut FMLA, both as job protected leaves that can run concurrently. Because he's got 4 weeks of sick leave, his employer is requiring him to use that first in its entirety before he gets wage replacement from the paid leave authority. So that is how his scenario plays out as a person who has longer tenure with a larger employer. Jamie works for a much smaller employer. They have 20 employees working in Connecticut. We're assuming it's 2022, so the law also applies to her employer, but she works part-time and she's worked for her employer for 2 years. She has 6 days of sick leave and 3 weeks of vacation time. And she does also hurt herself in a non-work related injury. So she does not have any eligibility for FMLA because she hasn't earned enough. She hasn't worked long enough and not earned enough hours in order to qualify for FMLA. But she does have job protected Connecticut FMLA leave in 2022 because she's worked for her employer for more than 3 months. Now, her employer also has a policy where she has to use her sick and vacation before she gets any wage replacement from the paid leave authority. And again, she then has to use that time up first, and then she can come to the pay leave authority for the remainder of the wage replacement for the time that she will be away. And for those that may have spouses that work for the same employer, right now under federal and state FMLA, those spouses are required to share their 12-week job protected leave for the circumstances that are listed here, bonding and caring for either a parent or a family member, depending on whether it's state or federal. But come 2022, the paid leave law will not require spouses to share their time for any reason. Let me go back a bit. Go back up. So let's talk a bit about private plans. I mentioned earlier that employers have the option of providing a private plan in lieu of the public plan if they meet certain criteria. If they choose to do so, then it's the employer and not the paid leave authority that's responsible for administering all the paid leave benefits. And the employer, however, then is not required to either collect or remit the contributions to the paid leave authority. Some employers are choosing to offer the private plan or paid leave as an additional benefit, and some, in fact, are withholding the 0.5% for the plan that they're creating. If they do decide to withhold the 0.5%, those can only be used for the administration of the plan. So either to pay benefits or to offset the cost, or any other related costs, but for no other reason. And under no circumstances, however, can the withholdings exceed the plan's contribution rate of 0.5%. If there is a circumstance under which that contribution rate is dropped by the state plan, then private plans have to follow suit by statute. If an employer is interested in applying for a private plan, they would do so by going to our website, ctpaidleave.org, and choosing the option, I want to apply for a private plan. The plan requirements are these: they have to offer the same or better benefits as a public plan, and a short-term disability policy is usually not sufficient because it does not offer leave for all of the reasons that are listed in the statute, and the plan has to be approved by a majority vote of all of the employees working in Connecticut, and most short-term disability policies are not subject to votes by the employees. It has to cover all of the employees working in Connecticut, and it can't cost employees more than the public plan does. So it's often that short-term disability policies cannot meet those criteria. Therefore, they're usually not sufficient to substitute for a private plan. There are a number of insurers, as you can see, who have been approved by the Connecticut Insurance Department to provide either a surety bond or a private plan insurance plan for those employers in the state who are interested. If you choose to be self-employed in this process, you do have to have a surety bond, and that can be acquired from one of these companies. All right, so we'll talk a little bit about registering your business. So why do you have to register your business? First of all, it's the only way that you can remit your employee contributions, which I mentioned earlier are due at the end of the quarter with a 30-day grace period. And that all employers, in order for us to know that you're aware of your obligation to withhold a 0.5%, that's why the registration is key. And if you're not registered, you will not be able to submit those contributions. And then we will come and actually have a dialogue with you through mail or some other kind of communication, asking whether or not you're registered and where your withholdings are. The registration process is a very simple one. If you come to our website, it's one of the first things that you'll see. It will step you through one by one, each step you need to follow. And there's also a checklist that you can print and download to gather the documentation and information you will need before you even begin the registration process. And you can see there's also a tab for applying for a private plan if you choose to do that as well. What should you do if you have not been withholding the contributions? There's only two words I have for you, and that is start now. There is a catch-up period. So we at the Paid Leave Authority did in fact negotiate with the Department of Labor for a catch-up period that applies to all employers who are subject to this law. So businesses have until June of this year to collect contributions retroactively from employees. That means that in addition to the 0.5%, you can collect an additional 1% of employee pay to catch up if you did not begin your withholding starting in January of 2021. The one thing that we do ask is to please inform your employees if you do choose to use the catch-up period or if you need to, because when employers do this, and they don't tell their employees, they are very unhappy, and they reach out to us and they make their discontent known, which then means that we have to have a conversation with employers. So if you're going to, or if you need to use the catch-up period, please let your employees know that that's what you're doing. We're often asked this question: what are some of the possible consequences of not withholding? Well, if the catch-up period doesn't work and you've not withheld and you're not making a contribution in a timely manner, our statute does allow us to hold the businesses personally responsible for those missed contributions. And that's why we went to the DOL and asked for a sort of a blanket ability for all employers to be able to make those catch-up payments. If even catching up through June doesn't work, you should let us know that, and we'll try to intervene for you on behalf of intervene on your behalf with the Department of Labor. Because the failure to withhold and remit contributions can affect an employee's ability to receive benefits. And we do have the right under the statute to impose other additional monetary penalties. We're really trying not to do that, which is why we asked for the catch-up period and are telling employers, if you haven't started, please start now. We have a number of additional resources that are available to communicate with you and your employees if you have questions about the paid leave program, and if they do too. If you go to the employer section of the Paid Leave Program website, you will find this employee rights poster, the employee rack card, which is just a smaller version of the poster, and a fact sheet, all of which present the same information about paid leave in different formats that we know people take in information differently. There are also videos that are available on the site, and the entire site is available in English and Spanish. Everything that I've spoken about today is encompassed in that employer toolkit, which is about 26 pages long, but it has everything in there that you should need. You heard me mention earlier that if you haven't started withholding, you should do so now, and you should let your employees know. This employee paycheck mailer that's on the lower right part of the screen is probably the most downloaded form that we have. I think the last time we checked, it was about 11,000 downloads, which can be used. We know it's dated for January, but some employers who haven't yet started withholding have been downloading it and then also including a little email message along with it as a way to inform their employees about the withholdings. Again, our website is ctpaidleave.org, and we're asking employers to engage in these immediate actions if you haven't already done so. So go to the website and register. If you haven't already done so, start your wage withholdings. If you're working with a payroll provider or a third-party administrator, the large ones, ADP, Paylocity, Paychecks, they're already very well aware of this program and should have already started long ago withholding and they will be remitting those withholdings on your behalf. Educate your employees by using many of the documents that I noted earlier, which again can be found in the employer section of the website. Scroll all the way down to the bottom. You will see them there, and visit our site regularly for any types of updates. We are here to help. We do not have a call center, but we do have a contact us feature on the site. You can use that contact us feature, enter your inquiry, leave a phone number if you need someone to call you back, and someone will get back to you. We just don't have the capacity to have a very, very large call center, but we wanted to have a way for people to reach us. There are also lots of FAQs and very helpful videos on the site. And again, it's available both in English and Spanish. So I'm going to stop sharing my screen and we can take questions. So thank you, Julie.
Great. Thank you so much, Andrea. So everyone, I've put a few links in the chat while Andrea was going through her presentation. So we have the employer resources and the toolkit. There's a link in the chat for that. I've also put the link for our contact us page. So if you do have any questions after this webinar is over, we are here to help. So please do utilize that contact us portal. So for our questions, let's see. You had mentioned sole proprietors are exempt or may opt in. What about partnerships and LLCs with no employees?
Right. So if you, I know there's so many different corporate and tax structures, but the general rule is this, and this is what we got from the Department of Revenue Services. If you receive a W-2, you're technically an employee under the statute, and those and employees are required to participate. But we also know that some businesses are actually sole proprietorships that have a different tax structure that make them employees for a whole number of reasons. So what we've been telling those people is if you don't have any employees and you're just receiving the W-2 as the sole employee because you're actually the only person who works for the organization, then we consider you a sole proprietor or self-employed and you can opt in. The moment you get employees, then they don't have the option of opting in. They have to participate in the plan.
Okay. And if you use a payroll company and they've started taking the paid leave contributions and they remit on our behalf, do we still need to register, or is this automatically done by our payroll provider?
No, you still need to register because some payroll providers are registering on behalf of their clients and some are not. So what we're finding as we're seeing the payments come in is that we do have some that are paying without registering. And here's the problem with that, that we can't give you credit for that payment if we don't know that you exist. And we won't know you exist unless you register. So before you ask, yes, we did try to connect with the Department of Labor and the Department of Revenue Services so that we could get more information from them so that you wouldn't have to register again. But for a whole host of reasons, and I can only say that we tried our very best, it wasn't a technological option that was available. So I apologize in advance that it feels duplicative, but we tried for that not to be the case, but you do need to register even if your payroll company is taking care of the withholding and the remittance for you.
Okay. And if an employer does not require their employees to use PTO before applying for state benefits, does the state then cover payment for the full time of the leave?
We still do. Yes, we do. But some employees are, because our maximum is 95%, and that is for that category of people who earn less than or equal to the minimum wage. We know that some employees want 100% of their wages. So some of them are taking part of their time from their employer under short-term disability and coming to us for the difference. And we've heard of scenarios where there's many different permutations of how people may use but their leave with their employee benefits and with their employer, I should say, paid benefits and us. But yes, they can still come to us, but they'll be paid under the formula that the statute dictates.
Okay. And what are the benefits of using a private plan?
So most employers tell us that the benefit of using a private plan is that they are in charge of all the benefits coordination. Some of our larger employers are already using a third-party administrator to do their leave absence management, is what they're calling it. So if you already are in that circumstance, this is just one more thing that you can add to that instead of managing this program separately. Others really want to be able to offer their employees just sort of a full array of services all in one place and would prefer that they not have to go to the state for one thing and then come to their employer for another. So they want to make it more convenient for them. And so those are primarily the reasons that employers have told us that they're offering a private plan. And we're seeing that sort of play out in the applications that we're seeing.
Okay, thank you.
Mhm.
And so our next question is, for the site that we use to register our business, would we be able to go back to that site in the future to see that our payroll service has been submitting their quarterly payments?
Yeah, so you should be able to see the status of your account, and it's literally called My Account. So you should be able to see that. And it's one of the really important reasons why you need to register, because you can't get access to My Account unless you do, because it gives you credentials that allow you to log in, and then you can see the activity in your account. If you find that once you register and you go into My Account and you don't see any payments or any record of payments, for payment activity for your particular entity, then that's something that you need to bring to the attention of the payroll provider as well. But we'll probably see it before you do.
Okay. And can an employer put in their handbook that they cannot use their PTO during a leave?
Hmm. So I am not as well versed in this area, and I don't want to really give any legal advice. So I could say if you're thinking about making changes to your policy to accommodate the changes in the PTO law, I'm sorry, in the paid leave law, that I would do that carefully. And I would do that with the advice of an employment lawyer. That's really the way I would answer that.
Okay. And will the employer need to utilize the portal if an employee requests paid leave directly to the authority?
No, this is all going to be driven by the employee themselves. So once they apply for leave, they do that directly through the paid leave authority. And there's no obligation on the employer's part to do anything else. We will contact you, as I mentioned earlier in the slide, to make sure that you're aware of the fact that they're leaving and to see if there's any other benefits that might offset, but the employer doesn't have any other obligation beyond that.
Okay. And would you be able to verify if a nonprofit educational school, K through 12, is required to participate?
Yeah, so it depends on how the school is created and functions. So there are some schools that are part of a larger not-for-profit entity. So this, I won't name any of them, but they may offer supports for people with intellectual disabilities or other disabilities, or they may be part of a larger institution that offers education as one component of the services that they provide. Those are not necessarily considered separate schools. That would be a private or not-for-profit, sorry, a private or secondary or elementary school that would be excluded. So if you're wondering if your particular entity, your specific entity is exempt from paid leave, then the best thing to do is this is the one time I'll ask you to actually use the chat and put your email in there, so that way we can get in touch with you and you can tell us what your specific circumstances are, and we can tell you whether or not your school is exempt,
Okay.
because it really
And
is case specific.
and Karen, if you could just drop your email in the chat for me, that'll come directly to me and not the group. So you can go ahead and just submit that there. Thank you. So we have a few questions that are a little more FMLA based here. Can
Okay.
you run Connecticut FMLA and federal FMLA concurrently, even if they are technically only eligible for Connecticut FMLA?
So you can, and I'm assuming that you're talking about the new law, you can run them concurrently, but what I will tell you is that it's not going to be easy. The way that the new law is drafted, that concurrence is going to be very challenging because not all of those reasons are the same. The family violence leave, for example, those 12 days is not a type of leave that's recognized under federal law, so you would not be able to run that concurrently. And because there's no hours worked requirement with the new law, and job protection attaches at 3 months rather than 12, this is going to be a much more challenging thing to do. And I know that, and I didn't draft it, but I apologize in advance anyway. But it's going to prove more difficult than how you're doing it right now, because right now both our state and our federal are almost identical, and it's much easier to run them concurrently.
Okay. And the next is also FMLA based. And this is basically the same question running concurrently with workers' compensation. And would employees be able to access paid leave through the state of Connecticut while concurrently having workers' compensation?
No, there's a specific statutory prohibition against receiving paid leave benefits and workers' compensation benefits or unemployment benefits at the same time. So you would not be able to do that.
Okay, and this one we've touched base on, but is it mandatory for self-employed to participate?
No, it is not. You may opt in, and if you do so, you have to stay in for 3 years.
Okay. Here's one that we get a lot. If my company is based in another state, but has some employees who work in Connecticut, do the same Connecticut paid leave rules apply for our employees in Connecticut?
Yes, they do. So if generally speaking, if you are paying payroll taxes for that employee or those employees in Connecticut, and you are also paying, let's say you have an your unemployment insurance obligation. I can't seem to speak today. An unemployment insurance obligation for those employees in the state. Generally speaking, then they are considered state employees in the state of Connecticut, and they are subject to the withholding, but they're also then, depending on their earnings, would be eligible to apply for benefits under the program.
Okay, thank you. And if the fund is short, meaning the trust, if the trust
Mm.
is short, will that 0.5% ever increase?
Statutorily, no. The way that the statute, unless the legislature decides to raise the 0.5%, then that's where it is right now, and it can't be changed unless the law changes. And I couldn't sit here today and tell you that that the statute is going to change, or that any of the legislators would be opening it up to change it. On the other hand, the statute does have a provision that allows us to adjust the benefit rate to keep the fund solvent. So rather than raise what the contribution rate is, we can lower the amount that everyone is paid in benefits down from that 95% and switch that formula in order to keep the fund solvent.
Okay. And as of right now, we have one more question. So I'd like to just remind everybody, we do still have some time. We want to make sure that we get to your questions. So if you have any, please use the QA feature at the bottom of your screen so that we can get you answers to your questions. So the next is, how long would a payment take to get to an employee? So from the time that they were approved to the time they would receive payment.
So we are still working through that, because we just had our board meeting this month where our board approved us using a third-party administrator for our claims benefits, because we do many things at the Paid Leave Authority, and we think we do them fairly well, but we're only a year old, and we are not standing up our own payment system or our own claims benefit system. We're going to be partnering with someone, with a provider, and I'll be able to share more information about that in a little while once the contract is fully executed. But at this point, we'll be working with them to determine we think our policy, that what we'd like to see is that it doesn't take more than 21 days. And that's what we'd like to work towards. But when we have a specific answer, then we'll be able to release that.
Okay. And will the program be publishing their actuarial reports on utilization and solvency annually?
Well, the frequency of publication isn't something that I had actually considered, but I know we'll be running them regularly, and I imagine that we will be publishing them, but I couldn't give you the cadence today, but we will.
Okay. All right, so that seems to conclude our questions for the moment. I just want to let everyone know that if you'd like to know a little bit more about paid leave, and you're interested in another webinar, I know a lot of us are zoomed out, but we do offer them. And we are partnering with some fantastic groups that are helping spread the word. So please do visit us at ctpaidleave.org and go to our events page, where you can see all of the different groups that we'll be partnering with and the different topics that we'll be addressing coming up in the future. I'd like to thank everybody, and Julie, I'm going to go ahead and pass the ball on to you.
Amber?
Yes.
Could we also mention the fact that there are past webinars
Yes, on
yes,
YouTube, our YouTube
okay.
page. I will drop the link to our YouTube page in the chat. Our YouTube page holds all of our past recorded webinars and the different topics that we've touched base on, anything from private plans to the legal aspects to how to register your business if you haven't already. So I'll go ahead and drop that in the chat for everyone. Thank you.
Okay.
Thank you to both of you. I know I learned a lot today, and I appreciate, your time and expertise. We also, through the Chamber, host a lot of informational webinars on, a range of different topics, so people can head over to our website, also waterburychamber.com. We have an events calendar with all of our upcoming events, and next week we'll be celebrating our 131st annual meeting for the Chamber, and we're going to be joined by our keynote speaker, who is from the United States Chamber of Commerce, and he's going to be talking to us about different public policy affairs and all that good stuff. So hopefully some of our members can tune into that. But thank you both again so much for your expertise today. We really appreciate being able to partner with, the experts in these fields and sharing that information with our members. So thank you, and thank you to all of the people who joined us. And if anyone, for some reason can't get a hold of you guys, because you've given us so many ways to connect with you, but if anyone has any questions and they'd like to reach out to me at the Waterbury Chamber, I also welcome that, and I'm sure I'll just direct them right over to you because you're the expert. So, but thank you so much, and hopefully we'll be able to connect again soon.
Thank you. Thanks, everyone.
Thank you so much for having us. Have a great day. Bye-bye.